In this lecture, we would like to discuss the very comparison between the provisions of international conventions or covenants relating to human rights and the very provisions under Indian Constitution. So, in that regard, we would like to discuss the provisions of the covenants on civil and political rights of 1966 in comparison with the provisions in Indian Constitution. So the comparison between the civil and political rights of the 1966 Covenant and fundamental rights of the Indian Constitution as answered under Part 3 of the Constitution of India truly reflects the Indian commitment and dedication to international efforts towards protection of human rights. So the following civil and political rights of the covenant are well placed under Indian Constitution much before their adoption in international sphere. So these rights, those under the covenant of 1966 relating to civil and political rights, that we found that right to life and liberty under the covenants provisions under Article 66 Clause 1 and Article 9 Clause 1 and the second provision relating to protection against arrest and detention as we found under Article 9 Clause 2, 3 and 4 of the Covenant on Civil and Political Rights and Equality before law as under Article 14 Clause 1 of the Covenant and the next provision under the civil and political rights of the Covenant of 1966 relating to that no one to be compelled as a witness against himself as provided under Article 14 Clause 3 of the Covenant and the very protection from prosecution as provided against in respect of convictions of offences and also protection as provided under Article 15 Clause 1 and regarding prosecution under Article 14 Clause 7 and the freedom of religion as provided under Article 18 Clause 1 and freedom of speech and expression as provided under Article 19 Clause 1 and Clause 2 of the Covenant, then right to peaceful assembly as provided under Article 21 of the Civil and Political Covenant of 1966 and right to move freely as provided under Article 22 of the Civil and Political Rights Covenant of 1966, then right to freedom of association as provided also under Article 22, then the next important provision under the Civil and Political Rights Covenant of 1966 is prohibition on discrimination as provided under Article 21. So in that connection, would like to that are the corresponding provisions that found in Part 3 of the Indian Constitution under various articles such as Article 14 of the Indian Constitution relating to right to equality before law and equal protection of law and Article 15 relating to the fundamental rights under Part 3 of the Constitution expressly prohibition of any kind of discrimination on the grounds of sex, religion, caste, race, place of birth, etc. and in particularly Article 19 of Part 3 of the Fundamental Rights of Indian Constitution, providing exclusively all those fundamental freedoms like right to freedom of speech and expression, then right to move freely, right to peaceful assembly, and right to freedom to form associations, etc. And also the very provisions of Article 20 relating to the restrictions and freedoms from convictions and prosecutions, then also relating to Article 21, exactly providing the right to life and personal liberty, and Article 22 relating to the prevention in regards to arrest and in particularly preventive detention, then Article 25 which expressly provides the freedom associated with freedom of religion as provided under the Constitution of India under Part 3 respectively. One dissimilarity found while the rights of the covenant are for all people all over the world, but the fundamental rights under Indian Constitution are available both to the citizens and non-citizens. So, certain fundamental rights are not available to non-citizens, such as Article 15, 16, 19, 29 and 30, and these particular fundamental rights are not available to non-citizens, and this stand was also decided by the apex court forever in the decisions such as the important judgments delivered, as in the very case of Hans Muller Wars of Nuremberg case in 1955, Anwar Wars State of Jammu Kashmir in 1971, and Chairman Railway Board versus Chandrima Das in 2000, which the position was held in such important cases. So now we would like to discuss the very covenant on social, economic and cultural rights of 1966, and in particularly the provisions under the Social, Economic and Cultural Rights Covenant of 1966, we found Article 6, Clause 1 provides right to work, and Article 7, subsection A provides equal pay for equal work, then safe and human conditions of work as provided under Article 7, subsection B, then conditions of work as provided under Article 7, subsection D, then maternity relief under Article 10, Clause 2, and also the very opportunity to children as provided under Article 10, Clause 3, and adequate standard of living as provided under Article 11 of the Social, Economic and Cultural Rights Covenant of 1966, also regarding compulsory education to children as provided under Article 13 of the Social, Economic and Cultural Rights Covenant of 1966. So, corresponding the above rights of the covenant are found their place in the directive principle of the state policy of the Constitution of India as under Articles 39, 41, 42, 43, 43A, 45, 46, Article 47, 48, 48A, and 49. In particularly, these articles respectively provided the same provisions under the directive principle of state policy, which is underlined under Part 4 of the Constitution of India. Even though these rights are not enforceable or justiciable, but the apex court or Supreme Court enlarged the meaning and scope of right to life while interpreting Article 21 of the fundamental rights under Part 3, which is the heart of the Constitution, to include all these above and unenforceable or unjustified rights as found place in the Part 4 of the Constitution of India, as for the very provisions under Article 39A of the Directive Principles of State Policy, we found it give direction to the state to carry out legislations for equal justice, free legal aid, while Article 41 of the Directive Principle of State Policy directs the state to work for right to work, education, and public assistance. And further, Article 42 of the Directive Principle of State Policy provides and gives direction to the state to carry out legislation for just and human conditions of work and maternity relief. And while Article 43 of the DPSP provides and gives direction to the state for to enact legislation for living wages for workers, and Article 43A of the DPSP provides and gives direction to the state to carry out legislation for workers' participation in the management of industries, while Article 45 of the DPSP provides for free and compulsory education for children, while Article 46 of the DPSP provides promotion of educational and economic interests of scheduled caste, scheduled tribe, and backward classes, while Article 47 itself of the DPSP gives direction to the state to raise the level of nutrition and standard of living and to improve public health, while Article 48 of the Directive Principle of State Policy gives direction to the state for organization of agriculture and animal husbandry, while Article 48A of the Directive Principles of State Policy, which was inserted under the 42nd Constitutional Amendment Act of 1976, give direction to the state for protection and improvement of environment and safeguarding forest and wildlife, while Article 49 of the Directive Principle of State Policy give direction to the state to carry out legislations for protection of monuments and places and objects of natural importance. So, in the very comparison in between the Covenants on Civil and Political Rights of 1966 and the corresponding provisions of Indian Constitution as enshrined under Part 3 of the Fundamental Rights and the Covenant on Social, Economic and Cultural Rights of 1966, in comparison with the provisions under directive principle of state policy as provided under Part 4th of the Indian Constitution that we have discussed in detail. And now we would like to conclude our discussion on the very comparative study on regarding the international conventions in comparison to the fundamental provisions under Indian constitutions relating to civil and political rights, and also in relating to social, economic and cultural rights, covenants of 1966 in relation to Indian constitution. So to conclude, we can cite the very observation made by the then Chief Justice of India, Justice P.N. Bhagavati, while addressing a seminar on human rights in 1980, as it was expressed by Justice Bhagavati that it is only through achievement of social and economic rights that civil and political rights can become a practical reality for the entire people of a country. Otherwise, civil and political rights will remain merely a teasing illusion and a promise of unreality. Insincere and hypothetical protestation of ideas intended to cheat and beguile the masses. So he rightly observed that the very urgent necessity of a country is to implement all social, economic, and cultural rights only to achieve in reality the civil and political rights as enshrined in the Covenant of 1966.